Sean Diddy Combs could be facing brand new charges in his criminal case out of New York as more and more apparent victims of his alleged bad behavior come forward with accusations in civil lawsuits. As a grand jury may be convening in the Southern District of New York, we're going to take a closer look at what this could mean for the disgraced rapper, and we'll break it all down with a current professor of law. Welcome to Sidebar, presented by Law&Crime. I'm Jesse Weber. Dramatic news in the legal saga surrounding Sean Diddy Combs, who's currently embroiled in scandal after scandal after scandal in multiple different courts. Well, is it possible that he could be slapped with new charges in connection with the government's racketeering conspiracy and sex crimes case? Well, it is being reported that a New York grand jury could be hearing new evidence in Combs' criminal case. In fact, attorney Ariel Mitchell-Kidd told NBC News on Wednesday that a male client of hers was going to testify before a grand jury in the Southern District of New York today. And a source familiar with those proceedings confirmed to NBC that a man is expected to testify. Now, grand jury proceedings are, of course, private. We usually never know what goes down behind those closed doors. But if a superseding indictment is filed, and that means basically what you hear it, supersedes or overwrites the first one, new charges, upgraded charges, could be a combination of both. This is very, very significant. And as a reminder, this is what the original indictment filed in September had to say. Quote, the defendant engaged in a persistent and pervasive pattern of abuse toward women and other individuals. This abuse was at times verbal, emotional, physical, and sexual. As part of his pattern of abuse, Combs manipulated women to participate in highly orchestrated performances of sexual activity with male commercial sex workers. At times, Combs and others acting at his direction made arrangements for women and commercial sex workers to fly to Combs' location. Combs ensured participation from the women by, among other things, obtaining and distributing narcotics to them, controlling their careers, leveraging his financial support, and threatening to cut off the same and using intimidation and violence. So, the charge of racketeering conspiracy comes from the idea that this is a criminal enterprise that Sean Combs was leading or directing, that it had this whole infrastructure to aid and abet Combs when it came to his alleged crimes. He's also charged with trafficking a victim to engage in commercial sex acts using force, fraud, or coercion, and he's also charged with transporting people for the purposes of prostitution. And additionally, to highlight this even more specifically, prosecutors say that Combs used his money and his power and his influence to organize what are called freak-offs, which are essentially orgies that involved hiring male sex workers, procuring drugs, filming these sex acts, and again, that he used force, fraud, and coercion to get what he wanted. By the way, what do I talk about all the time here on Sidebar? I talk about the law, right? Makes sense. Law and crime sidebar. I talk about legal rulings. I talk about legal decisions. But I have one for you right now that is a landmark one that has changed things in a very big way. Why? Because you can now legally trade on who will win the 2024 election. Yes, this is legal, and that's because our sponsor of Sidebar, Kalshi, went to court and won legal approval for election trading for the first time in over 100 years. So not only can you essentially bet on the 2024 presidential election, but with Kalshi, you can bet on who will control the House and Senate, who will win the swing states. Pretty timely. What's happening next week, right? And it's not just politics. You can bet on other future events too, like will Taylor Swift win Top Artist on Spotify this year? What's going to be the Rotten Tomatoes scores for upcoming movies like Gladiator 2? I actually think it's going to be above 85% personally. I think it's going to do great, but there's so much more and you're going to be like, wow, I can trade on that? This is the only place to trade on events like this in all 50 states. And you can sign up right now using our link kalshi.com/sidebar or scan the QR code on screen. And if you're one of the first 500 traders who deposit $100, Kalshi will give you a free $20 credit. That's kalshi.com/sidebar. Back to Ariel Mitchell-Kidd. She has represented different clients in this flurry of civil actions being filed against Sean Combs since his homes were first raided back in March. And there first started to be whispers about a federal investigation when that happened. Now, one of her most recent clients is a California Jane Doe who says that she was assaulted by Combs in 2018, but was able to escape and run to a neighbor for help. She also reportedly filed a police report, but says nothing really ever came of it. Anjanette Levy, host of Law and Crime's Crime Fix podcast, actually spoke with Mitchell-Kidd just a few weeks ago to learn more about her client, the allegations that she's making, and any proof of corroboration she might have. And according to Mitchell-Kidd, this Jane Doe brought up a woman named Christina Korum. Now, if you've been following this Sean Combs story, you're going to recognize that name because she is the woman who has been accused in at least one lawsuit of acting as Combs' right-hand woman, making sure that he had everything that he wanted, whenever he wanted it, including commercial sex workers. And she has been compared to Ghislaine Maxwell, Jeffrey Epstein's infamous madam. But to be clear, there's been no criminal charges filed against Christina Korum, and she has not been mentioned in any of the government's filings in this criminal case. But here is what Ariel Mitchell-Kidd had to say about her client's apparent connection to Christina Korum in her interview with Ann Jeanette.
She actually also identified Christina Korum, who Mr. Combs has called KK, and has talked about her in several interviews. And when he received the BET Award, where he talked about, thanks, shout out to Cassie for holding me in the dark times, he actually started off with KK. And she said, I never knew who that lady was. She was with him that night. It wasn't until recently, when the pictures have been coming across all over the internet of her, that she said, this is the lady who was there that night. It was the lady who I described to the police, who I did not identify or have a name, but that the Christina Korum lady was the one who had started to make jokes about sex trafficking my client, that she would be very good on the open market kind of thing. She said that kind of made her feel uncomfortable. And then she got a drink and then started to feel woozy. And then Mr. Combs first sexually assaulted her with an inanimate object, and then directed another gentleman who was there to then penetrate her while he was in the corner pleasuring himself, while Mr. Combs was in the corner pleasuring himself.
So this almost sounds like what's been alleged in these freak-off situations.
Absolutely. It was, and I've talked to several other individuals who I have not taken on as clients. I do not take on everyone who contacts me as a client. There's a level of due diligence that I do conduct, and a level of evidence that I need to see in order to make a good faith basis to file a complaint. I do have obligations as an attorney and the bar ethically, and I also have my own moral obligations. So when we come and talk about things of this nature, I always have to use some type of corroborating evidence, either from individuals as witnesses, pictures, something to corroborate that this actually occurred. So I've had other individuals call me and tell me very similar stories, but unfortunately, those individuals were not American citizens. They were foreign nationals who were trafficked into Miami by Mr. Combs. But because I could not verify their story, I was unable to take them on as clients.
Now, that was an anonymous female victim that she spoke about with Ann Jeanette, while she told NBC News that it's one of her male clients who is set to testify in front of this grand jury. Now, there is something that we can say almost with a certainty, that if there is a superseding indictment, that is going to affect the trial date, right? May 5th, 2025, the current scheduled trial date. New charges could mean new evidence to look at, new discovery to go through, new witnesses to find and interview, new experts to find. Depending on the charges, defenses could change too. It's a lot to go through. It's a lot that could change. So it seems to me, if that he really is subject to a superseding indictment, that trial date will be pushed off. Now, throughout all of this, Combs has staunchly maintained his innocence. And to be clear, he has not been found criminally responsible. He's not been found guilty. He has not been found civilly liable for any sort of sexual misconduct or sex crime. His legal team says they are looking forward to making their case in court, and they have said that Combs himself is likely to take the stand in his own defense and tell his side of the story. Well, we'll talk about that. Okay, so with all that in mind, I want to talk about these latest developments, and I want to bring in Professor Marian Braccia, who is a professor of law at Temple University. Professor, so good to have you. Thanks for coming here on Sidebar.
Thank you so much. Thanks for having me.
So what do you think is happening here? Do you think that a superseding indictment is a realistic possibility?
I think it's always a realistic possibility, especially if there are new witnesses, additional witnesses being brought before the grand jury. There's always the allowance for the government to bring a superseding indictment, to add, as you've mentioned, to add charges or to upgrade the already existing charges that have been filed. Of course, we won't know until the grand jury report or any indictment has been issued to know who testified and what the substance of their testimony was. But is it a possibility? It's always a possibility.
Would we necessarily know who testified? Would we know the identity of the people who testified?
I think it depends. I think if the grand jury report or the indictment named a complainant or a complaining witness or what we colloquially refer to as the victim, then yes, we would know. If it was someone who was a minor at the time of the offenses, then probably not. Ordinarily, minors are referred to by their initials or by a pseudonym. But when and if that person ever came to trial to testify in open proceedings, then of course their identity would be known because they would be sworn in and identified in front of the jury.
I am curious about what potential new charges there could be, or upgrading or revising certain charges. We'll get to that in a second, but I think the timing is interesting because do you think the prosecution learned about this, what could essentially be new evidence, before these new lawsuits were filed? Did they always know about it and wait to bring it to a grand jury? Why wasn't it brought originally? Remember, he's facing 3 charges. There was a question, could he be facing more? The timing of it, I think, is interesting.
The timing is interesting. I don't want to go so far as to speculate because obviously we don't know what the ins and outs of the investigation are. We don't know what kind of or how frequent contact the federal prosecutors from SDNY are in with the litigators and the attorneys that are handling the case on the civil side. But I don't think it's an unusual practice for criminal investigations to be informed by, sometimes even augmented by, civil litigation and the civil discovery practice. I don't think there's anything inappropriate or unethical about that. Those revelations from the discovery process on the civil side can help inform or help guide a criminal investigation or a decision on the prosecution side as to how to proceed or whether to proceed with the prosecution. So it might be a chicken and egg argument. It might be that the civil investigation started first and then was referred to the federal prosecutors or helped inform the federal prosecutors' decision making, or the other way around. It very well could be that the complainants or the would-be plaintiffs on the civil side weren't quite ready to cooperate with the prosecution or to testify before a grand jury and felt more at ease with pursuing a civil remedy first. So we really can't know until the investigation is revealed.
And look, it makes sense, right? Why do we have charges against Sean Combs? Because of the civil lawsuits. I mean, it seems very clear that Cassandra Ventura is, if not one witness, the star witness for the prosecution's case. You read the indictment, it seems her allegations make up a large part of that. So again, I think this is a fair example of civil lawsuits that actually might have sparked a criminal investigation and criminal charges. Call me skeptical, call me, I don't know what you want to call me, but I wonder, tell me if I'm totally off here. What else is happening right now? The idea that Sean Combs is actively fighting his bail. He is trying to make bail. He is trying to fight pretrial detention. And I've done other sidebars on this before, Professor, where I actually think he's made some really good arguments to suggest that he does deserve to be released. He's put forward an attractive bail package. He's countered a lot of the prosecution's arguments. He cited Mike Jeffries, who is the CEO, the former CEO of Abercrombie & Fitch, who was charged with sex trafficking crimes in New York. He gets bail. I don't have to reiterate a lot of the arguments, but I wonder if there is a motive for the prosecutors to say, hey, let's go forward. Let's get a superseding indictment so that we can really ensure that he is not, he doesn't make pretrial release. What do you think?
I don't know. I mean, it might be part of their strategy. I would say this though, that bail is the purpose of bail is to ensure a defendant's presence at a proceeding. It's to make sure that if there is any inclination to flee or to absent oneself from the proceedings, that they have some stake in actually appearing and participating in the prosecution or participating in the hearing. I think you're absolutely right that in Combs' case that he's invested ostensibly a lot of money in his own defense, that he would better be able to participate in formulating his defense or strategizing cross-examination theories with his defense team if he were available and out on bail. But I will say these bail motions have already gone up to the Second Circuit. They've gone up to the Federal Court of Appeals and been denied. I'm not quite sure.
To be clear, I don't know if the Second Circuit has denied it yet. I think they put it on pause because he wants to argue it in front of the new judge who's overseeing this case, Judge Arun Subramanian. Okay. So there is a chance it might go back to this. I mean, I think he held that appeal in abeyance. The court held it in abeyance, waiting for it. But look, he's been denied twice. I hear you. I guess I'm just of the perspective, like, the prosecutors, they have made a big issue that he had been reaching out to witnesses, that he's a danger on the outside. And from their perspective, if he is locked up, they could have more people come forward with more evidence, more witnesses, more alleged victims. They might feel comfortable to come forward if they know Sean Combs is not on the outside. So it makes me wonder that they want to say, listen, we have to keep him locked up because it's going to, we might be able to, if he's locked up, we might be able to get additional evidence in our case. I don't know if that's a legitimate concern, but again, that's what I'm thinking.
So I kind of like the way you phrased it in the second turn, which is to say that the prosecutors might be opposing a bail motion on behalf of the would-be complainants, on behalf of the would-be witnesses, saying, listen, this is going to have a chilling effect on people being willing to participate and being willing to testify before the grand jury, come in for prep sessions, testify in front of the jury when we actually get to trial. As a former prosecutor, what I hesitate to say is that the prosecutors would be inclined to just, quote unquote, add on and keep piling on charges as a means by which to keep the defendant incarcerated. So sure. I don't think that would be an appropriate use of the bail system or the pretrial incarcerative system. But I do agree that you're absolutely right. If there is intimidation or retaliation or any kind of witness tampering at issue or a risk for that the prosecutors would use that as the basis to oppose a bail motion.
And Combs has denied that, but that's a separate conversation. Let me ask you this. What do you think if you have a male, perhaps a male alleged victim of Sean Combs, what is the charges that they might be upgrading to? Is it the idea of, oh, we're going to throw in another sex trafficking count, another allegation to build up the racketeering count? I mean, one of the things that we have asked since the very beginning, because I've been following the Sean Combs saga for the past year, is I was surprised there was nothing in there regarding minors. And there were allegations, even before the indictment, that he had been engaged, perhaps, let's say, in soliciting minors. Since he was indicted, now we're seeing a flurry of lawsuits where people say, he sexually abused us when we were minors. And I don't know if this male witness falls into that category, but I am curious, if you're having at least another alleged accuser testify, what are the potential charges we might be looking at in a superseding indictment?
Well, remember that any of the charges that Combs is already facing are not gender specific. And as far as I know, in most states, and certainly under the federal code, a charge of sexual abuse, sexual violence, rape, sexual assault does not depend on the gender or gender identity of the complainant, of the victim. So if this male witness experienced the same forcible sexual activity that other witnesses in this case have alleged, then the same charges would apply to an indictment that names a male complainant. It is not gender specific, and it very well could mean that if this was all part of a criminal enterprise, that yes, there would be counts added to the racketeering charge. But I think it's very, very important for us to note and for the public to realize that sexual assault charges are not gender specific, and male or male identifying victims can be just as much victims of sexual assault as female identifying.
And we also have to be clear that not every instance of sexual assault would warrant a federal charge, right? It has to fit within a federal charge category. So, you know, if you're talking about somebody says that they were sexually assaulted by Sean Combs in 2010, or you have somebody who says I was sexually assaulted by Sean Combs in 1995, what are the ways that could rise to a federal crime?
So from what I understand from the indictment materials that I've read is that really it's the interstate commerce aspect of these activities that gave rise to the federal charges. So anytime activity crosses state lines, it affects what we know as interstate commerce. And that's what gives federal courts and federal prosecutors jurisdiction to bring criminal charges. And so if there was a witness or a paid commercial sex worker who was crossing from New Jersey into New York, or from Virginia into New York, or from one state to another, wherever they are within the United States, that would be considered activity that is occurring in interstate commerce and would give rise to federal jurisdiction.
Unless the charges change and you're dealing with solicitation of minors or something like that. Let me ask you this. You don't have to go back to the grand jury if you just have additional evidence to support a charge. So, for example, the racketeering it makes up, I think, 80% of the indictment, and they talk about forced labor, sex trafficking, kidnapping, arson, bribery, obstruction. They aren't very specific on individual instances. There's no mention of who the alleged victims are. There's no mention by name who the alleged witnesses are. If you get additional evidence, you don't necessarily have to go back to the grand jury to include that, not necessarily as another charge, but just as further evidence of a charge. They have to say, hey, this is an amended an amended indictment, a superseding indictment that just has additional facts, or am I wrong?
No, I think you're right about that. So, remember that a grand jury proceeding is essentially a mini hearing. It's a mini proceeding to decide and for the grand jury to determine if there is enough evidence to send the case forward to trial. So the entirety of the prosecution's discovery may not have been presented, and certainly doesn't have to be presented at the grand jury proceeding. So it very well could mean that when the discovery process opens, when the prosecution's material and investigative reports are handed over to the defense, it could mean that there's a lot more information presented to the defense in a discovery packet than was presented to the grand jury. So you're absolutely right. There doesn't need to be a superseding indictment if there's just more evidence on the same charges or regarding the same complainants that were already presented to the grand jury.
Do you think it's possible that the prosecutors had the ability to charge Sean Combs with more back in September, but they didn't, and reserve that and want to wait for a superseding indictment? And why would they do that?
I think it's possible. I think there's always a strategy decision at play. Do I think that it would that it streamlines the proceedings to kind of do everything in one fell swoop and have all of the witnesses presented at one time and have all of the indictments sought at the same time? Probably. But again, trials and investigations are organic, breathing, living, growing things. And so it very well may mean that even though it was the preference, or may have been the preference of the prosecutors to have a complete package, so to speak, back in September, if the investigation is evolving or growing and more people are presenting themselves and being willing to testify and share their experiences, then that might just lead to the necessity of a superseding indictment.
If the grand jury comes back, looks at this evidence, finds there's probable cause, sufficient evidence to move forward with charges here, when would we know about it? How quickly do you think this process would work if he's actually hit with a superseding indictment?
Well, I have to give you a quintessential law professor response, which is, it depends.
Yeah.
It depends. It depends on how quickly the grand jury hears the evidence. It depends on how quickly the grand jury deliberates and decides to turn around. And if they decide to turn around an indictment, it depends on how quickly the prosecutors decide to publicize it. So could it happen very, very quickly? Could it happen in a matter of days or even within a week? Sure, it could. Could it take months? Yes, it could as well. So we really don't know their timeline.
And if you are now dealing with federal charges related to minors, if that comes into play, I think this whole case changes. I think his whole defense changes, because a lot of the defenses that he seems to be raising now are the idea of, all these freak-offs, everything was consensual. There was no sex trafficking. There was no force. I wasn't forcing anybody to do anything. If we believe victim one is Cassandra Ventura, she was my girlfriend. Of course, I'm flying her around. We engaged in sexual activity. I'm just previewing what defenses could be, but consent seemed to be the main thing. If you're now dealing with minors, that all changes, right?
That does change. That changes in a major way. So I think the fact, obviously, there is evidence that the defense may want to use to cross-examine witnesses who have filed civil lawsuits because their credibility is at stake. And anytime a witness has, quote unquote, something to gain or something to make or to earn from the outcome of a trial, that goes immediately to their bias. So
Right.
It very well could mean that those witnesses, if they were minors at the time, would be cross-examined on the existence of any civil claims that they're bringing against Diddy. But the other thing that I think we need to keep in mind is that there are, and what makes prosecutions of child abuse, especially delayed disclosure child abuse, very, very difficult to proceed with and to prevail on, is the passage of time and the fact that there may be lapses of memory, there may be the absence of any physical evidence, if there was physical evidence to begin with. You have this flurry of activity and media around this prosecution, and all of a sudden that may weigh on these would-be complainants' decisions to come forward. So it does change the defense, but guess what? It also changes the prosecution and makes things a little more difficult for the prosecution to proceed with victims who may have been minors at the time of their abuse.
That's a really, really good point. And of course, I hate to say it, but we've already talked about it before in other sidebars, if these minors were drugged, and obviously that could affect recall as well. Professor Marian Braccia, thank you so much for coming on. Really appreciate it. Really enjoyed this. Would love to have you back as this case progresses.
Thank you so much. Thanks for your time, and have a wonderful day, and I'll be watching on my end as well.
All right, everybody, that's all we have for you right now here on Sidebar. Thank you so much for joining us. And as always, please subscribe on Apple Podcasts, Spotify, YouTube, wherever you get your podcasts. I'm Jesse Weber. I'll speak to you next time.